Madam Chair, Mr. Commissioner, Your Excellency, ladies and gentlemen, thank you for the invitation and the possibility to talk with you about the problem of interoperability of the systems that are used in the area of freedom, security and justice. My role today is to present the main lines of the reflection paper that has been signed by my colleague Giovanni Buttarelli, the supervisor, just a few days ago. The EDPS, as the supervisor of the EU institutions and the data protection authority of the European Union institutions, bodies and agencies, recognizes the interconnectivity of the public resources in the EU as the natural future for the information systems and for information exchange. That's something that we cannot jump out of. We are sure that the semantic, the organizational and the legal dimensions of so-called interoperability of the electronic services, including the large-scale information systems in the area of freedom, security and justice, will be carefully observed when we are talking about the interoperability solutions, both by the architects of the system, the users, the legislators, and both on the European and on national level. Knowing that in principle interoperability aims at developing effective and efficient information sharing to ensure the competent authorities on the national and EU level to get the right information at the right time, we know that the discussion we have started today is just the step in the much longer and probably never-ending discussion about the search for practical reuse of the data stored by the public administration. That is not a surprise for us, and that is not something that we are generally afraid of. European Data Protection Supervisor is of the opinion that interoperability, when it's implemented in the well-thought-out manner, may help to address some needs of the competent authorities using the large-scale information systems and help to reduce the costs of the operating of such system. Moreover, interoperability may also be in the interest of data protection, for instance, the interconnecting information systems which have closely related purposes and in addition which contain the very similar or identical data can serve the quality and can reduce or enable us to avoid the redundancy of the data. We want then to use this debate as the moment to introduce the idea of privacy by design into the whole discourse about the interoperability in the area of freedom, security and justice, and generally in the whole discourse about 21st century look at the information systems. Since introducing the interoperability is likely to imply the new or changed personal data processing, such changes would, however, require the clear basis in the legislation and have to be in the full compliance with the Charter of Fundamental Rights. In particular, any new or modified data processing would need to be clearly defined and in the relevant legal instruments and equally necessary and proportionate in the relation to the clearly stated objectives. We therefore look forward to get more information about the European Commission legislative proposal, and we think that performing a full assessment of the impact of interoperability on fundamental rights to privacy and data protection will be crucial for that. We already heard about the work of the high-level group, and we've been involved in the activities of that. And the opinion of the report of the EDPS was also included in the report of the high-level group. We have to, however, remember that these three proposals that are right now on the table and were somehow endorsed by the Council out of the proposed by Commission, the European Search Portal, the Biometric Matching Service, and the Common Identity Repository can be just the beginning of the longer discussion about the other services that will be proposed in the future. Because the more possibilities we have in interconnectivity, the more possibilities we try to use. So looking forward to read this legislative proposal, I would like to put just few things about the interoperability and our expectations. Interoperability is commonly referred as the ability of different information systems to communicate. Although interoperability is often considered as a merely technical concept, we consider that the present context cannot be disconnected from the question of necessity of data exchange, politically desirable data exchange, and legally possible. In other words, although interoperability of the information system will ultimately be implemented through the technical means, it must be the subject of the political debate, and we are very happy that it starts right now. We would like to recall the notion of interoperability and different layers of that, which appear in the discussion about interoperability solutions for the public administrations. It's rightly defined there that interoperability is actually the ability of the organizations to interact toward mutually beneficial goals, involving the sharing information and the knowledge between this organization through the business processes. All these words should be then also in our head when we are talking about semantics of interoperability. It was already mentioned here by Ms. Sippel that the same definition should mean the same thing in all the languages and in all the systems that are interoperable. Organizational interoperability and the legal dimension of that. We observe that making exchange of data technically feasible becomes in many cases the powerful drive for the exchange of this data. So the more you can, the more you do. Commissioner King has also addressed this subject a while ago. Interoperability would in principle aim to render currently applicable rules more effective and efficient. But for instance, the European Search Portal, which is envisaged to be by the Commission to implement the competent authorities to query several systems simultaneously instead of having the queries each system separately, means also that the information which is collected this way is a little bit more than what was so far. I'm not that sure if we really aim to the situation when we will have no new databases or no new information which is collected. Actually, this synergic approach to information may create the new one. At the same time, we understand that the Commission may now, or in the future, aim to extend the new possibilities of exchanging and cross-matching the data. For example, the Inception Impact Assessment refers to the use of shared biometric matching service to enable matching of biometric data held across the various systems. Similarly, common identity repository would bring together alphanumeric data, such as names and dates of birth, that have been stored in various systems for border management and security. The combined use of these two tools would enable a single identification using alphanumeric and biometric data to detect the multiple identities, which by itself is not bad, and by itself is one of the goals that we want to achieve. But once again, we have to remember that it means that the new information is then created. Sometimes we as data protection authorities are accused of being boring repetitive when we recall the principles of data protection. But this is our role. So let me be boring again and say that the personal data must be processed fairly for specified purposes. So EDPS is of the opinion that interoperability should not be an end goal of itself, but it should always serve the genuine public interest objective. The Inception Impact Assessment first refers to the general objective, developing stronger and smarter information systems for borders and security, and then it mentions the following specific objectives: ensuring the end users, particularly border guard, law enforcement officers, immigration officials and judicial authorities, to have a fast and seamless access to all information, facilitating and streamlining access to law enforcement authorities to non-law enforcement information systems where necessary to the prevention and investigation and detection and prosecution of the criminal offences, and finally providing the solution to detect and combat identity fraud. In this context, it's important to stress that general policy objectives, such as those that I listed a while ago, do not necessarily equal the public interest objective in accordance with the law, for example, according to the Article 52 of the Charter. They also do not form the purposes of the data processing according to data protection law. We encourage the Commission to clearly describe the specific purposes of the envisaged data processing. Objectives such as ensuring fast and seamless access to the databases may be useful means to the users, but consequently they may not allow the individuals to understand which of their personal data are possessed for what purpose and for what precise purpose, or to understand the consequences of that. Let me remind that just in the heart of the discussion about the new agreement with the United States on the Privacy Shield, the Working Party of Article 29, which is gathering all the data protection authorities, has formulated the list of the requirements for the mechanisms of interference in the right to privacy and data protection. The data protection authorities has created something which is called the European Essential Guarantees, and they have been later on recalled by the Court of Justice in the cases like Digital Rights Island, Schrems, Tele2, or the EU-Canada PNR case. And the fact that the processing should be based on the clear and precise and accessible rules, and that the processing has to be necessary and proportionate, were in the heart of that. Let me then conclude with listing the most important parts of our advice that we want to give to the European institutions when they talk about the practical use of the interoperability solutions. We support the interoperability when it's implemented in the well-thought manner and in compliance with core requirements of necessity and proportionality. Interoperability may be a useful tool to address the legitimate needs, may also help to avoid the redundancy and to help the quality of the data. The interoperability is often considered technical, but we understand that it is also necessary to decide if we really want to introduce it and what means from the legal point of view we want to take into consideration. We have to remember that we are at the beginning of the longer process, and whatever we will decide to create right now will never be abandoned. Once the money will be used to create the interconnected solutions, the new ideas how to use them will be appearing every 5 years. And I can almost bet that we will meet in this room in 2020 or 2022, or maybe even earlier, to discuss about the new things. I should probably not say it, but just looking at the note which was provided to the Council in February this year, and which lists the information systems that are right now discussed to be interoperable in the European Union, I can almost get that the FUNET, analytical word files of Europol, but also FADO, iTrace, Eurosur, EU PNR are just over the corner. These are the next systems that we will be discussing about. And once again, I'm not saying that the data protection authorities are generally against that, but these are the discussions that we have to be really well prepared to. And finally, particular problems of interoperability which aim to solve should be clearly identified in the forthcoming legislation, and we note that the Commission identifies certain problems, but sometimes it does not describe in detail what the precise issues are and how to solve them in the practical way. Whether the underlying problem is of the legal nature or the technical nature is also to be cleared. And the proposal should also clearly state for which specific purposes what categories of the personal data are used. Consequently, we consider that performing the full assessment of the impact of the interoperability on fundamental rights to privacy and data protection will be fundamental once more details about the planned initiative is known, and we are ready to provide the European institutions with the opinion in this legislative process. Thank you very much.
Thank you.